John Robert Conte, C-O-N-T-E.
All right, before we proceed, Ms. Abramson, you had an obligation elsewhere tomorrow morning. It doesn't seem like you'll be able to make it. All right, so.
Can I inquire of the district attorney if she thinks I can make it tomorrow afternoon? I suppose they can use me as a witness any old time.
All right, they apparently can squeeze you in there when their schedule would accommodate what we're doing here. So, okay. All right, Ms. Hassing.
Thank you, Your Honor. Dr. Conte, your expertise has been stipulated to for the purpose of this hearing, but I take it you have extensive experience in the area of family violence, child abuse, and evaluating people in those circumstances. Is that correct?
Yes.
And you've heard the discussion that's gone on here with regard to the effects of family history and the patterns of intergenerational abuse.
Yes.
Is that correct? Do you have any information with regard to patterns of intergenerational abuse?
Yes.
And what information do you have in that area?
Are you talking about in general or in this
Yes,
case?
in general.
Well, a history of violence in parents is extremely important in understanding a lot of things about parents, how they parent, what their attitudes toward children are, how they interact with their child. And so it can be, when it's present, extremely important in understanding the environment that produces children. And therefore, it can be helpful in understanding why children grow up to do certain kinds of acts.
And is there research which supports the conclusions you've just expressed?
Yes, there is some contradiction in the literature. I mean, about the importance of intergenerational transmission of some types of violence. But certainly, the field of mental health and the field of child abuse is quite interested and believes there is a connection, and there is some research which supports that there is a connection between violence done to parents and the violence they do to their own children.
And as an expert in this case for Lyle Menendez, did you request information on family history?
Yes.
And did you receive such information?
Yes.
And was that information important to you in forming conclusions?
Yes.
And why was that information important to you?
Well, the presence of a history of family violence is important in understanding how these parents interacted with their children, and understanding how they interacted with their children is important in understanding who their children are, or who their children became. And so it's important in understanding the acts that the children may have committed.
Now, when you received information from Lyle Menendez with regard to the behavior, say, of his mother, did you then look for support outside of the information he provided you to corroborate whether what he was telling you made sense, was reliable, seemed accurate?
Well, yes, but it's more than simply searching other information to get corroboration. It's also the search for information that would help explain and understand who his mother was. And so it's both to corroborate what he says, but it's also, more importantly, I think, in some ways, to understand who his mother was and how his mother acted.
Why was it important to understand who his mother was and how she acted?
Because his behavior is in part a function of his upbringing and his experiences with her over time. And so understanding who she was and why she acted the way she did is important in understanding ultimately what his behavior is.
And in forming conclusions about Lyle Menendez and what his behavior was, particularly with regard to the killing of his parents, were there things about his mother's background that became important for you in forming such opinions?
Absolutely.
What types of things were important to you?
Well, the abuse that she witnessed, I think pivotal in her development was the divorce that took place between her parents at 3, the fact that her father continued to come around, the fact that she was apparently teased or ridiculed by neighborhood children, that daddy was at their house, presumably with their mother. These kinds of factors help us understand why divorce was such a big thing to Mrs. Menendez, and why keeping secrets was extremely important to her, because she had painful experiences with divorce and secrets in her past.
And did you receive information which allowed you to determine whether she bonded with her mother?
Yes.
And was that information important in terms of deciding or evaluating whether she could bond adequately with her own children?
Well, it's important in understanding her capacity to bond. It's also important in understanding a range of behaviors that we hear described about her. So it's not, bonding is one factor, but there are others.
What other factors were important in forming opinions for you in this case?
Well, her emotional extremes, her temper tantrums, her drug and alcohol use, things that she would say when angered. So it's not just the developmental bonding between the child, but it's her whole symptom picture can be in part understood by her early life experiences.
And were these early life experiences or family histories that you gathered with regard to her important components in forming an opinion with regard to Lyle Menendez?
Yes,
And did you also receive information about Jose Menendez's childhood family?
yes,
And was the information you received about his childhood family important in forming conclusions in this case?
yes.
What information did you rely on in that regard?
Well, a number of factors. I think the fact that he was overindulged, exceedingly overindulged, had a nursemaid that followed him around for a period of his life. The fact that he was not disciplined, that his mother was probably overprotective. His coming to the United States as an adolescent and feeling that he was not treated as he was due, and his efforts to sort of overcome how he was treated when he came as an immigrant, or some of the factors off the top of my head about his development that is important in understanding who he was and then how he interacted with his children.
And in understanding who he was and how he interacted with his children, is that important in evaluating who Lyle Menendez is?
Yes,
And is it important in understanding how he behaved on August 20th, 1989?
Absolutely.
And so would it be fair to say that the background of both parents is critical to you in forming opinions with regard to Lyle Menendez and his behavior on August 20th, 1989?
yes.
Okay. Anything else? I have nothing further.
People wish to examine?
Yes, Dr. Conte, what is the conflict in the literature right now regarding the value of intergenerational abuse?
Well, there are some studies that have shown that if your mother or father was physically abused, then that may get passed on. You may be more likely to abuse. Now, some studies have failed to find such a connection. Depends a little bit on the type of abuse. For example, about 60% of sex offenders are thought to have been abused in their own childhood. The effects of watching a mother be battered may have a different effect on men than it does on women. So, for example, some studies anyway have suggested that a man who watches his father beat his mother is more likely to beat his wife, whereas a female child may be more likely to grow up and tolerate abuse or marry a violent person. So there are different studies that have looked at different types of violence. Some studies have looked at, for example, alcohol abuse and substance abuse, and some studies have found that tends to get carried on. I'm not saying this very clearly, but what I believe the literature suggests is that some studies show a direct correlation. Some studies have failed to find a direct correlation, and so science is sort of slowly putting the pieces of the puzzle together, a clear picture on whether absolutely there is intergenerational transmission. At this point, it looks like there is for some types of abuse, at least in some studies.
And you subscribe to the school that intergenerational abuse is valuable in forming assessments about people having been abused.
I think, well, I don't know whether it's a school, but I think from a mental health point of view, understanding family of origin is important in understanding clients who come to you. I would not say that absolutely a family of origin, a violence in the family of origin will 100% assure that there will be violence in the present generation, because I think the research and my own clinical experience is contradictory on that. So that it is one factor, it is not absolutely diagnostic of abuse in a next generation to find it in the past, but it certainly ought to be something that you ought to have information about a host of family of origin issues in understanding clients who come to you for some assessment.
Did you see anything in Mrs. Menendez's behavior that was different from her mother's behavior vis-a-vis the father's affair, that is Jose's affair versus Kitty Menendez's father's affair. In other words, she reacted differently than her mother, correct?
Well, there were certainly differences. How much was her control and how much, I mean, for example, Mrs. Menendez stayed with Jose. Now, my understanding is that Mrs. Menendez's father left her mother. So, the marriage didn't stay intact. I don't know whether that's because Mrs. Menendez was acting differently or the males acted differently in that scenario.
Mary Louise Menendez was very punishing to her husband upon learning of his
Yes.
affair, whereas her mother was very accepting of her father, in fact, invited him back into the house perhaps for further sex. Now, I believe you also indicated that Jose Menendez's overindulgent childhood was something that you found significant,
Yes,
and yet you saw signs in his treatment of his sons that was not overindulgent in terms of the abuse, correct?
that's correct.
All right, so there was no intergenerational transfers of the overindulgence.
That's correct.
Okay, do you find that significant?
I find it significant in that there was something happened in his development which helps us understand why he behaved the way he did. Now, in one sense, that is intergenerational, intergenerational in the truest sense, something in the past in one generation affects something in the present generation. But you're absolutely correct. He tended not to be overindulgent of his own kids. So he took what happened to him in his life experience, and for reasons that I'm sure we'll talk about, he acted differently toward his kids. It still, though, is important to know that he was overindulged, or appears to have been overindulged, in understanding his behavior. So the correlation is not 100%, but the importance of the historical factor and understanding seems pretty important.
Did you make any attempts to go into the upbringing of the parents, Jose and Mary Louise Menendez? In other words, the defendant's grandparents, to look into how they were brought up, to trace back this intergenerational abuse?
Some, but it's the farther you go back in generation, the fewer people you have to talk to. So it's very difficult to get a whole lot of information about, for example, Mr. Menendez's mother's upbringing, although I did try to do that.
Because the information is less reliable the older it is, right?
There are fewer people to tell you about it. It could be an issue of reliability, or it could just be that nobody's available to give you that information.
I have nothing further.
All right, thank you.
Thanks.
All right, did the council wish to argue further? Let me hear from the prosecution.
Yes, Your Honor. It appears that the main portion of what sought to be elicited from Dr. Burgess is that Mrs. Menendez had been subject or had witnessed abuse, and therefore she would be tolerant of abuse, therefore that explains her conduct, therefore Eric Menendez is telling the truth. That appears to be the logical chain that is sought to be proved by the defense. This is somewhat akin to profile evidence in that it's predicting behavior of someone that we certainly can't interview. And it, under 352, I think what we're doing is opening up the door to extensive examination and cross-examination about the Menendez parents. Now, under 804 of the evidence code, it says that when an expert witness relies on the opinion or statement of another person, the other person may be called and examined by an adverse party. Of course, that's impossible in this case because the statements relied on, specifically Mrs. Menendez's statements to Dr. Summerfield, she can't be called and cross-examined. And and so it seems to me that although this thesis that intergenerational abuse is somehow relevant, the testimony even of Dr. Conte indicates that there is a conflict in the literature. There is a conflict in this case with that thesis, which is that Mr. Menendez was not abused, but somehow that his history is still important. And because of the speculative nature of this particular information, because of the potential to litigate the history of the Menendez family, when in fact the main issue is the perception of the defendant on the night of August the 20th, it seems that we're going rather far afield in order to try to corroborate Eric Menendez's testimony, which is really what is being sought, because Dr. Burgess kept saying, I'm trying to corroborate, and that somehow the intergenerational abuse corroborates Eric Menendez. I think it's an improper opinion for her to give, and it's based upon, obviously, information which is suspect and unreliable and should not be admitted.
All right, did the defense wish to respond?
Just very briefly, Your Honor, it isn't only being offered to corroborate. I think the way Dr. Conte explained it makes it clear is that we haven't been able to get into this because of repeated objection and the sustaining of objections over the course of the whole trial. We have always felt it was logically relevant to show who these parents are as complete and total people, because that would explain how they affected their children and how they affected their children's behavior. And it is their children's behavior that is on trial here. And I think what both Dr. Burgess and Dr. Conte are saying is that you really cannot evaluate the family interaction, which is the whole source of this homicide, whoever's theory here is correct, without trying to understand who the parents are.
Well, as we know, the prosecution has been trying to prove who the defendants are, and there have been objections by the defense to evidence that the prosecution wants to introduce to put on a whole picture of the defendants and their background, and the court has sustained many of those objections. So
Because
that analogy is not appropriate.
But Judge, you know what?
We'll go beyond that. I'm just responding to that argument, which is a specious one, and let's get to the specifics of this offer of proof.
Well, the specifics of my offer of proof has to do with explaining the behavior of Mary Louise Menendez, first of all, her reaction to what happened to her in childhood, an explanation and a corroboration of why and how she wouldn't and didn't intervene in the sexual abuse of her son, an explanation and a corroboration of why she inflicted both emotional and physical abuse on her son, an explanation and a corroboration of her extreme concern with image and keeping secrets, because that was part of what she learned, and an explanation and corroboration of her son's testimony that she would not consider divorce, both sons' testimony, and why she would, in this modern day and age and in this state, be so opposed to divorce when that seems so counter our current culture. And I think for a jury to accept and understand the truthfulness of the assertions that have been made concerning her attitudes on all these subjects, that it is relevant to know what her childhood experience was. With respect to Mr. Menendez, I think Dr. Conte made it clear that it isn't so, and Dr. Burgess was alluding to it as well, it isn't so much that he, as a recipient of abuse, perpetuated it, but that he, as a recipient of bad parenting of another sort, being overindulged, not disciplined, overprotected, and encouraged in notions that I suppose are least modestly called megalomania, that makes a certain amount of sense as to why he exhibits these kinds of behaviors within his family. In other words, who he turned out to be with respect to family issues. He was the little king, the little prince in his family, which no one ever crossed, and he was precisely the same in his nuclear family as he was in his parents' family. He who must be obeyed. And I think Ms. Lansing wanted to address the court as well.
All right.
Yes, Your Honor. It's our position that this is material that is customarily relied on by people in the field that both Dr. Burgess and Dr. Conte are practicing in, and that is that there is an importance of family history, one in a predictive sense, secondly in a corroborative sense, and I think we are not attempting to predict behavior here. We have two individuals who are on trial for their life who have told certain stories, given certain information, described certain patterns of behavior by their parents. Now, the question is going to be, did their parents engage in those forms of behavior, and what's the significance of them? But the threshold issue is, did the parents engage in those forms of behavior? Now, once we have an idea of who these parents are, and the likelihood that they did engage in those forms of behavior, it's extremely corroborative of the information that Lyle Menendez provided both to their experts and to the jury by way of their testimony. And I think that what Dr. Burgess and Dr. Conte explained is that there are strong correlations between what our parents do when we're small and then what we subsequently do as parents. There are patterns that we learn and that we repeat. And when we see the similarity of the patterns, I think it becomes very compelling. The district attorney asked if or comment on the fact that you can ask the questions of the people you're describing, but in this case we can't because Mr. and Mrs. Menendez are no longer with us. There are other people who were in those childhood homes who have described behavior, who saw that same behavior, and who can corroborate it. Both of Jose Menendez's sisters have testified here in court. They're available. They testified to some of the behaviors that we've talked about here. In terms of the adult behavior, they were not allowed to testify to their childhood behaviors. The court knows we have relatives of Kitty Menendez available to testify to what happened in that childhood home. One of the questions that Mrs. Buzanich asked of Ann Tyler, as I recall, was whether Dr. Tyler had interviewed Mrs. Menendez, and if not, why not? She asked a number of questions about whether there had been questioning of parent and relatives to corroborate this type of information. So I think although we didn't go into it in great detail here, the fact that Jose Menendez is indulged and spoiled as a child, the fact that he is robbed of his heritage in his teenage years, extremely critical times, and spends the rest of his life recapturing the status to which he thinks he's entitled, and has this sense of entitlement about him, is extremely corroborative of the behavior and personality that is described by the defendant. So, based partly on the fact that it is the information traditionally relied on, and based partly on the fact that we need to be able to present evidence to these juries which make them understand the world that Eric and Lyle Menendez lived in, I feel that this information is highly relevant and probative and would not be unduly consumptive.
Well, you earlier indicated it would just take an hour or so of the testimony of the witness, one family member, but obviously from this offer of proof, we have testimony of at least two analysts or two experts for each defendant, and probably more depending on how many experts are being called. So it's more than that.
No, I don't think that's accurate, and I think that Dr. Tyler has already testified and not gone into that matter. So it's my understanding that Ms. Abramson would elicit this information from Dr. Burgess. We would elicit it from Dr. Conte. Those would be the only two experts who would be testifying to this area. And we do have the one sister yet to put on who would talk about the specifics in terms of her observations. Now, if the prosecution wants to challenge the veracity of the experts' information in the areas they're talking about, then there would be other people available. But that's something the court could decide under 352 later down the line. It would be our intention at this point in time to elicit the information from the two experts and the corroboration from the one witness. And that one witness's testimony was the 1 hour that I was talking about.
What is the people's response in regards to refutation or dispute of any of the evidence to be offered by the one sister of Mary Louise Menendez?
Well, Your Honor, we've not been able, because of the court's order, to interview Brian or Milton Anderson's, who were her brothers, in regards to what.
Well, certainly since this matter was last discussed, you could have asked permission to do so. It's certainly now a matter that didn't have to wait until now for you to explore.
Right, Your Honor. The people's position is that if the court's going to permit recitations of facts by the experts as to the intergenerational abuse, then we should be in the position to put in every statement Mrs. Menendez ever made about her family and the effects of her family upon her own children to refute that. And so we would then be conducting interviews with people we've heretofore not talked to in order to put on her state of mind, since the necessary link in all this is Kitty Menendez, and she's not here. And what they're saying is she saw abuse on both ends, and therefore she tolerated it. And from that you can extrapolate what her state of mind is, and from that you can extrapolate that Eric Menendez is telling the truth. And if the court permits this kind of testimony, then of course the court would I would assume permit the factual basis for the testimony, which would be the testimony of Joan Vandermolen. At that point, the people would start to try to rebut that testimony. So I don't know precisely what information we will have to do so. But
Well, I didn't quite understand what you said. You would put on every thought that Mrs. Menendez ever had. What did you mean by that?
If Mrs. Menendez said, my mother acted that way and I'm not going to act that way, I think that would be relevant now, because her state of mind has now been put in issue by virtue of the fact that the experts have been allowed to testify about what her state of mind would have been, because that's basically what you're saying.
All right, assuming she made that statement and that was a reflection of her state of mind,
Yes.
then it
and
would be
that's
admissible. Okay.
Yeah, and so we would now be into a litigation of Kitty Menendez's state of mind throughout her life in relationship to her children. And, but more importantly, what they're trying to do, what the defense is seeking to do, is to prove that Eric Menendez is telling the truth, or that Lyle Menendez is telling the truth, because the mother's mother had an abusive relationship with her husband, and that is what they're trying to do. And that is, we've argued this before, it's remote, it's unreliable, it has nothing to do with the issues that should be addressed under 1107 of the Evidence Code. And because of that, and because of the undue consumption of time and the undue confusion to the jury and confusion of issues, this should not be permitted.
Well, what I'm trying to do is ascertain if there will be an undue consumption of time. Clearly, as has been observed before, we do spend some time discussing the matter, but it's an appropriate area of inquiry because it could open the door to quite a bit of other evidence being offered that could prolong this trial even longer than its projected length,
Your Honor,
which is obvious concern to everybody. Let me say this, that in regards to the offer by the defense to introduce evidence relating to Jose Menendez, his upbringing, and all of that has been discussed here and articulated by Ms. Lansing, as well as to some extent by the witness Conte. That evidence is remote, speculative, and not probative, and the court would sustain the objection under Section 352 of the Evidence Code. The court really looks at that as the defense perhaps throwing in a little more and asking for the court to cut out some and let some in. But regardless of that, the court finds that even if that were not the situation, and the defense has never really made a serious offer of that before today, as far as the father's upbringing and all this that has been discussed here, court finds that evidence is pure speculative in nature and remote, and under Section 352 of the Evidence Code, any probative value of that is substantially outweighed by its potential to confuse issues and prolong the trial and undue consumption of time, and the court would sustain the prosecution's objection to it.
Menendez, the first of his siblings to testify. So it's not that we've never been interested, but since we have more evidence with respect to Mrs. Menendez, I think we're pursuing more.
All right, well, the offer here has been at this point made in regards to Mrs. Menendez, and the strength of the defense position is different relating to that offer of proof than it is in relationship to Mr. Menendez, and the court is cognizant of the evidence that has been introduced during this hearing by both witnesses in that regard. The only concern I have is whatever balancing there might be in relationship to any undue consumption of time, and I'm still not 100% clear on that as to what the prosecution's offer is and what it is that we would be opening the door to. Well, their position is they don't have it because they didn't have a chance to investigate it, and I'll give them this evening to do that and see if they can come up with any response tomorrow morning on that.
Your Honor, we have a witness who read Mrs. Menendez's diary after she was deceased, which diary disappeared, but we have a witness who was a security guard at the home who read the diary when she...
Okay, let me say this. Rather than do it piecemeal, I'll give you this evening to pursue the matter and pursue it with any of these relatives that you said you didn't have a chance to speak with, to see if you can come up with any offer of proof that would have any bearing on the weighing process the court is involved with as far as the amount of litigation that might be opened by this offer of proof here.
May I just say that if the court is going to permit intergenerational testimony about Mrs. Menendez, we would request to talk about Mr. Menendez to test the validity of the theory. In other words, our objection is to the testimony about Mrs. Menendez. And if the court allows that, then the people will cross-examine about Mr. Menendez's history.
Okay, you can make that part of your response to, or the court's invitation to provide the court with a detail of whatever it is you think would be introduced to refute this evidence. And I'll let you do that tomorrow morning so that if there's any need to do any investigation or contact witnesses this evening, you can do that.
All right, so we're now absolved of the admonition not to contact these witnesses.
You would have, that would have been dealt with last week or whenever the issue was dealt with before during the testimony of Dr. Tyler, if you had asked. And there are other matters that relate to your cross-examination of the witness that were subject of some objection by the defense. Is that correct?
Yes, Your Honor.
Okay, let's deal with those as well at this point so that I'll excuse the jury until tomorrow at 9 o'clock and then we can resume here with this material. So let's have the jury out so I can excuse them for the balance of the day.
One of my favorite supplements is Cunol turmeric. Turmeric helps with healthy joints and inflammation support, and Cunol has the #1 doctor recommended form of turmeric. Cunol, the brand I trust.
Jurors are all gone now, so we can resume.
I have a request that might save us a lot of talk about matters talked about in the past. The list of things that people want the court to consider yet again is the screenplay content, the issue of the same alibi being used in the burglary, Craig Heinberg, which is that other coach that talks about Eric being in his house and painting things and going through his wallet. And I would suggest to the court that we have filed written pleadings on this, the so-called same alibi theory of the burglary, which lays out all of our arguments about why the people don't have that evidence in good faith to go forward with it in any event. I would invite the court to read the Craig Heinberg statement again to that section of the transcript where the issue came up before. I would invite the court, if it thinks it's necessary, to revisit our pleadings on the screenplay. And we would like an opportunity to look at all these pleadings again. So my request, bottom line, is when we come back at 8:30 tomorrow and deal with these 402 issues, and give the court an opportunity to see these things. So we don't have to keep saying the same things over and over. Even I get tired of hearing them talk.
Well, the issue really changes as the trial progresses. So these are not being relitigated in the same context. They come up in different contexts and have to be addressed separately. Regarding the facts don't change, and you're familiar with the facts. The reasons why the prosecution wants to introduce this evidence might change, and that is why we are going to have this hearing now. As far as the burglary alibi situation, that was discussed before during the testimony of Dr. Tyler, as I recall. And, well, at least during the testimony of the defendant, and I believe it came up during Tyler's testimony as well.
This has to do with the fact that John List Sr., one of the victims, there was a note from a sheriff that John List is saying, that Eric Menendez is saying that he was at the movies the night of the
Yeah, we were up at the sidebar and we talked about that last week.
No, we weren't.
Yes, we were.
We weren't.
Well, it must have been a different trial because,
It must have been another.
believe me, I heard it from you folks. No, it was recently. It was recently.
Well, then can we?
You were asking for how, or there was a discussion as to how it could be proved, whether it came from the defendant in his statement to the sheriff or some other
Right.
source, and I excluded it at that
was the
time.
walkie-talkie purchase, Your Honor.
No, it had to do with the movie, and that there was the same alibi that was offered in some statement in a note that the sheriff had.
All right.
That arose last week.
I don't think, I think the people, well, whatever. I think
Well,
people weren't seeking that, they were seeking walkie-talkie.
No, they were seeking this because that's how I remember it. It was
Okay, well,
just
I'm sure
a
you're
recent
right.
discussion.
Okay, well,
right.
I don't know what's changed since last week.
What is the people's offer of proof in relationship to that? There was a discussion last time we dealt with a matter that there really was no source of this information that the people could offer as to why it was excluded.
Yes,
Is
Your
it still
Honor.
being offered by the prosecution?
Yes, intended to ask Dr. Burgess about it because she has now testified to his mental state on the night of the offense, which is something that Dr. Tyler was not testifying about. She was just testifying about the abuse. We're now at the point where the defendant's mental state is an issue. It's been placed in issue. I think it's firmly an issue now. And because of that, I think that things that she should have considered in assessing his credibility should be brought up. And it seems from her testimony that she's rejecting totally the people's theory of the case, which is that it was a premeditated killing versus an impulsive act based upon fear. Because of that, I think I should be entitled to ask her questions about the defendant's prior conduct, especially criminal conduct, in which he used the exact same alibi, to see if that in fact
The
is her opinion.
issue that arose the last time we discussed this was that you couldn't prove that this is what he said.
Still can.
So,
Well, we have a police report that indicates that Eric claims that he and Andy Pierce were at the movies on the 14th.
claim to who?
It's from Mr. List, who is.
Okay, has he been interviewed? I mean, the man's out there. Have you spoken to him? And
I haven't spoken to him, that Mr. Furiyama has been speaking to him.
There, Mr. List is apparently out of town a lot. I have messages into him.
I mean, since June of this year, he's been out of town throughout the whole trial?
Well, I've spoken, I guess it was to his son when I subpoenaed him. So he's under subpoena, but as far as actually talking to him, I've called several times. He has an answer machine. I've left messages on his machine.
Right. In order to make a good faith offer as to what this evidence would be, it seems to me that he should have been interviewed. And without that, you have secondhand information as to what he might or might not testify about. So at this point, as I said before, this evidence is not admissible unless you can make a further offer of proof.
Your Honor, but
You're
isn't-
saying she should have considered this even though it's unreliable.
But isn't the information about intergenerational abuse second?
That's a separate issue. If you want to make that argument, we can do that. But if they have a witness regarding intergenerational behavior, such as a sister of Mary Louise Menendez who witnessed these things, that's not secondhand, that's her observations. So that's different. Now, if Mr. List is available and is interviewed and has something to say about the matter, then you can bring it up. But as I've said before, at this point, it's not reliable.
I wanted to ask the court about the screenplays written by Eric Menendez, specifically the first one. And the argument is that during her testimony, Dr. Burgess related the suicide note left by Mrs. Menendez and talked about it as an example of her ideation. And it's our argument that Eric Menendez's ideation is at issue here more so than his mother's suicide note, because it's his state of mind that's crucial on the night in question and not his mother's. And because of that, and because if the suicide note is admissible to show her state of mind, why aren't the screenplays admissible to show his state of mind, especially in relationship to his ideation, which is now an issue because his mental state is now firmly at issue?
All right, well, I'll permit you to make inquiry of her outside the presence of the jury, and we can explore that briefly so that I can have more input on the matter before ruling.
I don't even know what counsel's talking about. This is ideation.
Well, regardless of the words she uses, I'll permit the prosecutor to inquire of the witness outside the presence of the jury, realizing again that getting into that is a area that is covered by Section 352 of the Evidence Code as to why it has previously been excluded. So I want to hear some offer before we get into it.
I'm waiting to give you all.
Well, it'll be by way of examination of the witness.
Should we put it back in?
Well, let's finish what we're doing here. We have other offers here. There was, what else on your list of matters,
Great.
Mrs. Bozanich, that you have?
Your Honor, there was Is the court familiar with the Craig Heinberg incident, so I don't have to relate it again? It was a tennis coach.
It was referred to briefly during the examination of the fellow who was a director of tennis at somewhere where the Mr. Heinberg worked at one point.
The information is that when Mr. Heinberg was away from his home, that Eric Menendez broke into his home and rifled his wallet and moved around, did not steal, but rifled his wallet and moved around his credit cards. And then on another occasion, Eric Menendez came to his house and painted some bleachers pink outside of his home. And it's our argument that this kind of conduct.
There was also a reference to some confrontation, a physical confrontation, as I recall. At least that was what Mr. Kuriyama indicated.
Eric Menendez threw his shell credit card in the field behind the tennis court when they had the last day that Craig Heinberg taught Eric Menendez. And I wanted to question Dr. Burgess about this behavior on the part of Eric Menendez in relationship to her opinion that he was acting out of fear on the night in question.
Well, Your Honor, it's very hard to see the connection with that and why he's acting out of fear on the night in question. She hasn't made any comment about any behavior on his part that is relevant to this. They've never proven up this behavior because they've never had a theory of relevance to prove it directly. They would have to prove it by extrinsic evidence. As I've indicated before, we've interviewed Mr. Heinberg, and he gives a very different view of the events than the police report reveals. I don't know if Mr. Kuriyama has ever himself spoken to him since the time he was interviewed by the police.
When was that report taken?
It was a long time ago.
It was
September 8th of 1989.
And have you interviewed him yourself?
I have not personally interviewed him. I have reference to Mr. Heinberg again. Actually, this is out of the burglary case. This is Sharon Ginsburg gives information about Craig Heinberg. She had spoken with him directly, and that Eric was caught vandalizing Craig Heinberg's home, burglarizing his home, taking money from his wallet, and taking his car without permission.
Well, that's the same information as what's in the Heinberg report, except when we interviewed Mr. Heinberg about the Mrs. Ginsburg allegations, he absolutely denied and refused them. But the point of it all is, I don't see any connection between his hijinks at Mr. Heinberg's house and whether he was in fear on August 20th, 1989, particularly since I don't believe he saw Mr. Heinberg after 1987.
Your Honor, the defense has put on testimony about every incident of abuse to Eric Menendez from the age of 0 till now.
That's not true.
The defense,
All right, one side speak at a time.
his whole life is at issue now. The witness indicated that she was given police reports. I would assume that this is one of the police reports given. Counsel's questions seem to assume that she was given everything. Because of that, I should be permitted to ask her if she considered this incident in evaluating Eric Menendez. This conduct which is inconsistent with the other kind of conduct that she's talked about. She said she related things about his past that this is inconsistent with, and I think that people should be permitted to examine about it. She's been able to make her opinion on reports that she got from the defense attorneys without personally interviewing the witnesses. She should be able to make opinions about reports of witnesses that the prosecution wants to offer.
Well, certainly you can ask the witness whether she read the report and whether she considered it. And we'll have to play it by ear after that.
Well, I would ask her that before they can even ask that they be in a position to prove these matters if they have to. I don't even know if Mr. Heinberg is available. They don't know if he's available. They've never talked to him. I've never seen him return on the service of a subpoena.
Okay, regardless of all of that, they certainly can ask whether she read the report and considered it. Use it as a basis in any form for her opinions.
My understanding, Your Honor, is if she did not use it as a basis for her opinion, that it's inappropriate.
Well, we're going to first do one thing at a time, and we're first going to have those questions asked. And it's certainly not prejudicial to do that in front of a jury, since it's a matter that would have no meaning to the jury other than just those questions being asked.
I disagree, because in this case, when Mr. Doss was testifying, the people asked a number of questions before the court finally stopped the line of questioning about Mr. Heinberg. Mr. Kuriyama started it out by describing it as a burglary of Mr. Heinberg's house, which it never was. And so I think that.
You're saying that's before the jury, that the jury knows that the defendant was involved in a burglary of Mr. Heinberg's
They
house?
certainly know Mr. Curiano asked that question of Mr. Dawson. I objected, and there was a hearing at the sidebar. And then he was allowed to ask whether or not Mr. Dawson was aware that Eric was a, quote, discipline problem for Mr. Heinberg. And Mr. Doss said yes, and then there was a whole other series of objections, and nothing further was done. But they do have some notion that there is some wrongdoing, I mean, in affiliated with Mr. Heinberg's name.
All right, well, the wrongdoing apparently would be encompassed by those answers given by the witness and no further. The fact that a question was asked and objection sustained is not something that's before the jury. It's not evidence. So I don't see any problem in asking those questions before the jury. All right, what other areas did you want to go into?
Your Honor, this is not a subject of a court too, but I'm planning to ask the witness if she's familiar with the book by Mr. Moniz, When a Child Kills. And I was planning to ask her about a specific passage in this book which bears some similarities to the details given by Eric Menendez.
Well, Your Honor, I think it is improper for the people to ask a witness questions from a source unless they first establish that the witness is not familiar with the source. I'm familiar with the existence of that book. Surprisingly enough, I've never read it. But whether or not the witness relied upon it and based her opinion on it. And if they want to pursue that line of questioning outside the presence of the jury, that's fine. But to ask if she's familiar with it, I guess anybody who's watched Mr. Moniz on talk shows is familiar with the existence of that book. I don't think that's the appropriate answer.
All right, again, the questions can be asked whether she considered it and used it as a basis for her opinion.
And the
As
last-
far as the specific passage, at this point, I'm not going to permit that to be read to the witness
All right, Your
in
Honor.
front of the jury.
What is the court's opinion that this witness has indicated that the amount of detail given to her by Eric Menendez was one of the things that convinced her of the truthfulness of his statements? If we can show that there are details of abuse in the literature available, which could form the basis of fabrication, are we not permitted to do that?
I don't understand what you mean.
All right, for instance, if there was an abuse in which a jar of Vaseline was found, right? If there was an abuse in which a jar of Vaseline was found right next to the bed, and in the same, I'll just read out this.
Can you read the book before August 20th, 1989? Because I think the real problem is.
Okay, counsel, one person at a time. Just because an idea bubbles to the surface, you don't have to articulate. Let me hear from the prosecution. Let them finish off what they want to say. Let them finish off what they have to say.
In one particular incident related in the book, which dealt with sexual abuse as the basis for parricide, there was mention of Vaseline in that incident. There was mention of sex used to punish the child. There was talk in there about the defense attorney's need to collect all photos, diaries, letters, and everything in order to substantiate the abuse. There was indication that the defendant in this case was scared that he was homosexual because of it. There was reference to concentration camp inmates. I believe Eric Menendez talked about the fact that he read things about concentration camp victims. There's information on page 66 that the father's sex was getting rougher, that the sex included being poked with pens and pencils. And lastly, there's a part about, and this is not specific to this particular defendant, but that the clothing that the particular person was dressed up in sweaters in order to make him look younger for purposes of testifying. Now, as far as these specific instances, now, I believe Ms. Abramson's argument is that the defendant would have to have read this before August the 20th of '89. It would be our contention that he would have had to have read it before he testified.
Why didn't you ask him that?
That's my point.
Why didn't you ask the defendant that?
He didn't.
Well,
Well,
then what is it that this
So we're
witness is
gonna
supposed to say?
So we're going to ask the defendant if he read it, and he's going to say no. Just like he said, no, I didn't see the BBC movie. So what does that prove? It doesn't. If he says no, does that mean he can't put it into evidence?
Well, what does it prove that the witness has read it?
Because it means that there are things that are available. There's literature available which gives detailed accounts of sexual abuse from which a person could fabricate a defense.
When was this book published?
1991, Your Honor.
Yes, in 1991.
Came out in
Wait, one person at a time.
November 1991, it was published, and I can easily make an offer of proof that all of the details to which Eric Menendez testified were revealed in September and October of 1990. Every single aspect, except wearing a sweater to look younger in court, which he didn't reveal, was revealed like over a year before Mr. Monis's book was published, and over a year before he ever knew Mr. Monis.
Your Honor, Mr. Monis went to visit Eric Menendez in the fall of 1990. We have a jail visitor slip to that effect. That was before Judge Rothman issued his edict. Mr. Monis was visiting by the fall of 1990, and I think that Mr. Monis was aware of these particular incidences at the time that he went to interview Eric Menendez.
So your suggestion is that Mr. Moniz scripted this thing, and that's how the evidence has resulted in what we've seen during the trial. Is that what you're going to argue, or is it?
I'm going to argue the possibility of that.
Okay, and how did you propose to do that? Is what I'm trying to get at, as to how you propose to get that evidence before the trier of fact.
I was going to ask the witness about it, and then in our.
Well, what are you going to ask her?
I'm going to ask her about the possibility. Well, I really don't want. First of all, the witness is in the courtroom,
Right.
and I really don't want to outline everything that I'm going to ask.
Well,
her.
just in general, then, what is it that you wanted to explore?
I wanted to explore with her the possibility of how a defense can be fabricated with this. And so I told the court in advance what I want to do to avoid any possible accusations of prosecutorial misconduct. I would like the ability to develop this on cross-examination, and then when it seems right to get into this area, we can approach. I wanted to give the court some time to think about this before I did it, and I wanted to ask the court's permission to do it before I did it. But I don't, at this point, feel that I should have to outline exactly what I'm going to ask the witness, especially when she's in the courtroom, and then tailor her examination to what I've said.
All right. Is this this material encompassed in a whole book, or just one chapter, or what is it?
Well, the particular material I've made reference to is in a chapter dealing with one specific anecdote about one child. And if the court wants to review it tonight.
No, I don't. I've said before, I didn't have any intention of reading the book. It's a book written by one of the lawyers representing the defendant in this case, and I don't think it's appropriate for me to read it. If there is some evidentiary value in it, or that it's going to be introduced, and you feel that it's essential that the court review it prior to that, I guess I'll have to look at it, but that's not my intention.
Just for the court's benefit, the 352 analysis, obviously, what the people are talking about here is an allegation of fabrication by the defense team. And this is no small thing. And I can tell you that our response to that would be a very complicated entanglement as witnesses of current lawyers, prior lawyers, the calling of Mr. Monis, in order to refute this specious notion that Mr. Menendez was either told by Paul Monis what to say or read Mr. Monis's book a year later and somehow, therefore, astrally projected the jar of Vaseline back into his bedroom on August 20th so that the Beverly Hills Police Department could photograph it. So I think this is not only is this a specious approach, but using this witness to make that approach is inappropriate and improper. If the people wanted to confront Eric Menendez with the source of his information so he could be in a position to explain or refute it, that's one thing. But they chose not to do that, and now they want to backdoor it through a totally uninvolved witness, uninvolved in any notion of fabricating any kind of information, in order to avoid the defendant telling them exactly where his memories and thoughts of the molestation came from. Mind you, this is a prosecution that did not ask one single question on cross-examination to test the details, the validity, the veracity, the common patterns of the sexual molestation that Mr. Menendez testified to. Rather than do that, which is the method that the law provides to them for testing veracity, they want to raise a scurrilous issue that a national expert in parricide is creating a defense in this case, and they don't even have the nerve to call him to raise the issue. They want to raise it with an expert.
To call who is
Mr. Monis. If they think Mr. Monis has done this, they should call him as a witness and try to prove it.
All right, he is a lawyer for the defense, is that
He's
right?
not a lawyer for the defense.
He's been identified in declarations filed by the defense as a lawyer for the defense who is consulting the defendant at the jail. And the court has received those declarations and authorized him to be a visitor at the jail as the lawyer for the defense.
He is not representing the defendants in this courtroom. He is an expert, he is a consultant, and he is our penalty phase investigator. He is all of those things.
All right, well, he was identified, to my recollection, as counsel for the defendant or as counsel for the defendant.
I've never identified him as counsel. for the defendant,
Somebody has filed a declaration in that regard.
But he is a lawyer,
Somebody
and
for the
as such,
defense.
even though he's not acting in the capacity of a lawyer on this case, he is entitled to visit the attorney room, and that's what those declarations were. Access to the attorney room declaration.
Okay, my recollection is he was identified as counsel, one of the lawyers for the defendant. That's beside the point. Did the defense for Lyle Menendez wish to be heard at all on this subject? Or is this exclusively an issue that relates to Eric Menendez?
At this point in time, it appears to relate exclusively to Eric Menendez. I haven't heard that they have similar plans for Lyle Menendez.
All right, this book was not marked as an exhibit, but lodged with the court. The defense asked the court to read it. I assumed at the time that the defense had read it and felt that there was something in there that the court would benefit from by reading it, but apparently the defense has not read it.
Some of the members of the team read it, I haven't.
But the person who offered it hadn't read it.
Well, I was just a messenger, Your Honor. But I do think there are things that could have benefited, but I understand the court. You can read it for whatever purpose.
No, the only purpose of reading it at all would be to read those portions that relate to this controversy that we're now addressing, and for no other reason. Have you read it? Anybody here read it, such as Ms. Morrissey, since she is co-counsel on that subject, the one that we're now discussing?
Yes, okay.
Okay, and is there any value in the court reading those portions that relate to this particular subject that we're now discussing?
I think Ms. Lozanich read the entire content of the portions that she wishes to question about. I mean, it's an anecdotal part of the book that talks about prior other instances of molestation of other kids. It certainly doesn't in any way indicate that it was based on this case or has any connection to this case.
Like the prosecution's argument is just the opposite, that this case is, the evidence offered by the defense is based on what is in that book.
Your Honor, my argument is that there are publications available such as this one, which contain anecdotes from which a person could fabricate this kind of defense, and the pages would be pages 47 through 81.
The problem with that, Your Honor, is that the people have made no effort to prove, as indeed they could not prove, what materials Mr. Menendez has access to in jail. And that's the mischief in their trying to introduce this evidence in this backdoor way, rather than by questioning the defendant about it, where he could explain his limited access to materials, where he could explain how frequently his cell is searched, and other matters such as that. I mean, the court knows the cell was searched. Every single piece of paper was taken out in June. These kinds of searches happen routinely in the jail.
In June where?
June of 1990.
Okay.
You remember that?
That was 1990. You said June. I thought you were talking about this year.
No, in June of 1990, and there have been searches periodically since then. So if there were materials such as these in his cell, one would think the prosecution would be able to prove that. Instead, they want to argue in the absence of any evidence that he somehow had access to materials to fabricate. And he never has.
Your Honor, we have been denied access to the jail effectively because of Judge Rothman's order. And to suggest that that we would have learned about what kind of material he's been given is absolutely contrary to the facts. We do not participate or authorize or have any knowledge of jail searches.
What I'll do is review those pages. What were they again?
47 through 81.
Wait. What were they?
47 through 81, Your Honor. I can give the court my copy, but it's
I
paper clipped and
I think
marked.
we still have it here. It's been sitting on the evidence tray. So,
There's also one other page, which is page 253.
Well, if the court's going to read it, I would hope the court would read things in context rather than isolated bits.
well, I'll read it to get a better feel for the areas that the prosecution has alluded to here that are subject to their offer. All right. What else did the parties wish to discuss other than what we've already discussed this afternoon regarding cross-examination?
I'm going to ask her if she conducted a physical examination of Eric Menendez to substantiate whether the child abuse occurred. I don't know if she did or not. And I'm going
Okay.
to ask her if she was made privy to any physical examination of him and what the results were, and if that added to a detracted from her opinion.
All right. Any objection to that?
Yes, and to object to that, that's not the scope of the testimony. She did not conduct a physical examination, as counsel well knows, because I told her that. And therefore, I don't think it's appropriate to ask an expert about things that she wasn't hired to do. She's not a medical doctor. She has not performed physical examinations that I'm aware of for the protection of child sexual abuse. And therefore, I don't think it's appropriate to ask her.
Well, depending on the foundation that is established, it might very well be an area of inquiry. So if the prosecution can establish the foundation, then they can ask those questions. All right, anything else?
That's the end of my list. I believe that Ms. Abramson wanted to discuss the 1016 issue. All right, well, then I have nothing else to discuss.
All right, well, her discussion had to do with the timing of the hearing of that
Oh,
matter.
that's after the cross-examination, I'm sorry, Your Honor.
Anything else? All right, are there matters that, other than the issue that relates to intergenerational behavior, that would be the only matter that would require a hearing prior to testimony before the jury, as I recall.
Intergenerational, you already did that.
No, we haven't ruled on it yet.
I know.
I said, other than that,
Well, we have
other
to-
than the people's offer of proof in response to it. As I've said, the people are going to offer evidence that would provide the court with sufficient basis to balance the probative value versus the potential prejudice and undue consumption of time. So that'll be done prior to the defense completing its direct examination. It might be that the people might need a little time tomorrow morning and they can start their cross, and I'll permit you to reopen on that subject before they finish. So depending on the status of their investigation, we'll know more tomorrow morning.
Obviously, my purpose would be to finish it before cross.
That would be mine as well. I would,
But we do what I guess we're going to continue with this 402, so this would be the screenplay and the play claim.
well, the screenplay would be done very briefly outside the presence of the jury. And the Heinberg, I already ruled on that.
Right.
Okay.
And there's another issue as well.
All right, anything else? All right, let's have everybody back ready to go at 8:45 so that we can proceed at that time tomorrow and resolve, if we can, any of these other matters.
Well, what's my status with Judge Randy, where I haven't talked?
Well, I believe, told them the afternoon, is that right? Okay. All right, we'll be in recess till tomorrow morning at 8:45.